specialising in international dispute resolution and commercial litigation. And more importantly, in this capacity, I'm a member of the ICC Australia Steering Committee. So welcome to our first episode of Conversations with ICC Australia for 2025. For those of you who have tuned into previous episodes, you'll be aware that these are intended to be relatively short, online recorded conversations between two speakers on a topic we find interesting and hope you'll find interesting as well. And based on feedback, we've been trialing mixing up the time zones a little bit so that we can have one that is more US friendly for those of our members who are based in the US. So thank you to any night owls from Europe who have dialed in, and to the early birds in Asia who are joining us as well. Before we begin, I would like to acknowledge the traditional owners of the lands on which those of us in Australia meet. In my case, that's the Gadigal people of the Eora Nation, and to pay respects to elders both past and present. And it is my absolute pleasure to be joined by Tim Nelson today. Tim's most important qualification is obviously that he's an Australian, but he also happens to be a partner at Skadden, Arps, Slate, Meagher and Flom, based in New York and specialising in international litigation and arbitration. And he represents clients in a variety of disputes involving cross-border and international law issues. Now, in preparation for this, I spent some time looking at Tim's various profiles and accolades, and the list is very long. And I thought it might be more interesting to hear from Tim a little bit about how he ended up from going from a law student studying at UNSW to being a partner practicing in international arbitration at Skadden in New York.
It's my pleasure. Thank you. And good morning, all. So I took a BA-LLB from UNSW in the early 90s, and then I worked for a federal court judge, Judge Shepard, and then I worked at Freehill, Hollingdale and Page, as it then was, for a number of years, with 1 year out of that spent working in state government. And then in 96, I took a master's at Oxford, and then I worked in England for a number of years after that, and then requalified in 2000 to take the bar. And just by chance, it was a good time to be looking for jobs in the United States. It was the .com boom, and people were leaving law firms. I tell people who ask about this was not a master plan. The move to the United States was very much family driven rather than part of a master plan. And if you wanted to have the overseas experience, I wouldn't hop between London and New York. I would pick one, or I would pick California maybe. But I mean, look, it's worked out all right. And in fact, you mentioned UNSW. One of a very sweet encounter I had a few years ago. I was asked to give an after dinner talk in New Jersey and something, and I gave the bio details to the host, and he was so gracious. But he said, and you know, he's come from one of the best law schools in Australia, the University of New Wales, and you can't get better than that. And he did it with such grace that I just couldn't correct him. And here's the man from New Wales. So anyway, there you go. You get moments like that.
Yeah. And so now you find yourself in the US, which is obviously a big economy, and for many years has been a key enforcement destination globally. And that's resulted in sort of the quite significant body of jurisprudence building up in relation to award enforcement, including against sort of a subset of that being against states under the New York Convention and the ICC Convention, and also in relation to the execution of assets. And quite interestingly, more recently in Australia, we've also seen cases commenced against states, particularly Spain and India, which have resulted in some important decisions, particularly on foreign state immunity. And as it happens, we actually have now some crossover in our respective practices. You've obviously been involved in enforcement cases against Spain in the US, and there are parallel proceedings ongoing here in Australia in relation to some of those same awards. You were also involved in the, as I understand, the underlying arbitrations and some of the enforcement proceedings in relation to the Devis Award against India, which arose out of a satellite investment. And there are also parallel enforcement proceedings here in Australia where I'm acting for the investors and now the assignees who've taken those awards. So in all of those cases, foreign immunity has been an issue. That's obviously a rule of international law, but in both the US and Australia, it's codified in domestic statutes. And that's typically, at least in my experience, has been the first hurdle that we've had to overcome when we're running award enforcement cases. And it's one that both the US and Australian courts are currently still grappling with. So in both jurisdictions, as I understand, you can correct me if I'm wrong about the US here, the base position is that a state is entitled to foreign state immunity unless one of the enumerated exceptions in the statute is made out. Can you tell us a little bit about what the exceptions are in the US that investors who are looking to enforce awards are typically relying on?
Yes, so in the US, as in Australia and the Anglosphere, we have restrictive immunity. In the Anglo-Australian system, it flows from Trendex and its Trentex and its progeny. And in the United States, it flows from two sources. One is that in 1952, the Eisenhower administration issued a thing called the Tate Letter that said that previously sovereigns were just presumptively immune, and unless the executive lifted the immunity, you were out of luck. And from that point on, from 1952 on, the restrictive approach applied. So if the activities that were the subject matter of the award were commercial in nature, you could overcome the immunity, and there were other grounds. And in 1976, Congress codified this in the Foreign Sovereign Immunities Act, which for the most part tracks international usage. It has two, if not three, interesting features. One is that there's an express thing called the arbitration exception, which means if the foreign state agreed to arbitration and is subject to an enforcement treaty, such as the New York Convention or the ICC Convention, immunity is lifted over proceedings both to recognize and enforce the award. We have a thing called the waiver exception, which is actually closer to the Australian and UK statutes, I think, but I could be corrected. We have a commercial activities exception as well. We also have a thing called the expropriation exception, which won't apply in arbitration, but is sort of an interesting gloss on all of that, which is basically designed to get the Castro government and bring it into court. The result is that if you are enforcing against a sovereign, you are in federal court, and for a whole lot of reasons, you are almost certainly going to be in the federal courts of Washington, D.C. That is the District of Columbia, or its immediate appellate court, which is called the DC Circuit. You probably won't be in the other courts, which means you have to get a judgment of the District of Columbia and then port that judgment under the Judiciary Act and the rules about porting a district court judgment to places like New York or Los Angeles or Delaware, which are more likely to be the places where the assets are. But that's a road that takes you face a few speed bumps. You have to overcome sovereign immunity. You have to persuade the court to enforce the award over the sovereign objections, which will come down the line in addition to sovereign immunity. And then you have to find the jurisdiction which is best to pursue the sovereign assets in. So that's the way it works.
Yeah. Well, just coming back to the arbitration exception, which is the first one you mentioned, I think that's an interesting point of difference between the regime in Australia and the regime in the US. Certainly in the cases that I've been running in the enforcement context, we haven't relied on the arbitration exception. We've only relied on the waiver exception. And our Foreign State Immunities Act quite deliberately by design adopted what's called the sort of narrow view of the arbitration exception, where simply an agreement to arbitrate is not taken to convey consent to subsequent enforcement proceedings anywhere in the world where the award might be enforceable. I think that's quite different from the US and the UK as well. So that leads us to a greater reliance on the waiver exception, and where it might apply the commercial transactions exception as well. But I'd be interested in your take in terms of the arbitration exception and its application. An issue which we've seen is states using the foreign state immunity objection and the award creditor's reliance on the arbitration exception to that immunity to argue that there is no arbitration agreement. So almost like a jurisdictional objection at the immunity stage. How has that been dealt with by courts in the US?
Well, you begin just on the waiver point. And I usually represent the award creditor. Every award creditor will argue that if you have an agreement to arbitrate plus entry into the New York Convention or Exit Convention, you have a waiver. The problem with that, and I don't think it's an insurmountable problem, is that the United States Solicitor General has urged the DC Circuit not to address whether the waiver exception is a pathway to jurisdiction. It's done that because the United States is this is the executive branch of the government, is always imploring the courts to be conservative on how sovereign immunity works, because the United States has a lot of assets in other jurisdictions and exposure to litigation worldwide. And whatever the DC Circuit says to waive Venezuela or Georgia's or Spain's immunity will be applied mirror image to United States if it's a defendant in the courts of Amsterdam or Hamburg or whatever. So that's one factor that you've got to grapple with. Getting to the arbitration exception, I'll use Russia as an example because I'm not involved in the UCOS case, but it's a prime example, and it's a juicy award. It's 50+ billion. Russia has been held liable to pay a boatload of money to a group of UK investors in UCOS. Those investors obtained the award in The Hague. It has survived annulment challenges in the courts of The Hague and the Supreme Court of the Netherlands. The same award creditors have taken the award to a judge in DC and said, how is about it? Please enforce this judgment. Please make this award a judgment. Russia has thus far been litigating and has stalled judgment because Russia's argument is this is an award rendered under the Energy Charter Treaty. Yes, we signed it. We never ratified it. And although there's a legal holding based on the wording of this treaty that signature alone will make the treaty applicable to Russia, we disagree. And because the Foreign Sovereign Immunities Act requires the existence of an arbitration agreement, the District of Columbia Court can hear us relitigate this point afresh, even though it's been determined in the courts of the Netherlands, even though it was the subject of a jurisdictional challenge in the award that was fully adjudicated. Because the Foreign Sovereign Immunities Act requires proof of an agreement, that can be relitigated afresh in DC. And the same logic is being applied across the board by all sorts of sovereigns saying, this is a treaty award, but there was no valid investment. Therefore, our agreement to arbitrate under the treaty was conditional upon there being a valid investment. Therefore, there's no agreement. And so it goes. And this is an issue we had to confront in the Spanish litigation, but it's an issue being confronted across the board. The response of the courts to date has been, hang on a minute, as long as there's presumptive proof that you signed it and that the treaty and the award aren't forged, the requisite showing of jurisdiction is made. Anything else that you want to argue we can deal with at the merit stage, but sovereign immunity has been lifted just by reason of those threshold pieces of proof. That these sovereigns are still trying to catch a favorable breeze in the Supreme Court of the United States on this issue. They haven't yet. They might never, or they might. But, and this is the same issue that the Australian courts faced, if you actually entertain these arguments, it turns every single court in a New York Convention, any member of the New York Convention, any court, any Australian court, any Singapore court, any UK court, into a sort of second annulment jurisdiction under the guise of a sovereign immunity defense. And whatever else, that's deeply unattractive, I think, to the judges. So that's why the High Court of Australia issued its decision in Antin, and it's why the other courts in the UK elsewhere have done the same and said, look, we're not going to allow sovereign immunity as a sort of general open sesame to relitigate jurisdictional issues that were put to bed years ago.
Yeah, that's really interesting to see that approach. And as I said, because we don't have the arbitration exception, or we do have an arbitration exception, but a more narrow form where you really need to establish the commercial transactions exception as well. It hasn't come up in quite the same way or quite as squarely as it has in the US. But it was something that Justice Jackman grappled with from a different perspective in the first instance decision in Davis in India, where there was an issue about to what standard you need to prove the existence of an agreement to arbitrate for the purposes of immunity and for the purposes of establishing that the New York Convention was engaged. And he held that it was a prima facie standard of proof. So quite similar in a way to how the US courts are approaching it, but from a different perspective. If you could prima facie show the existence of an agreement to arbitrate, in that case by the tendering of the award, the bilateral investment treaty, and the terms of appointment in the arbitration, that was enough. And then substantive debate about the existence of an arbitration or investment or anything that was to come at the substantive enforcement stage under any Article 5 grounds that were raised.
And who could argue against the brother of Wolverine?
Must be right.
Yeah. So that's going on. And the case you're referring to is still actively being litigated in the United States as well. So including one part of the Davis case, and I try not to say too much about it because I was involved, but one part of the Davis case is on appeal to the United States Supreme Court right now on a different issue.
Yeah. So what is the status of the waiver exception? I noticed that in the most recent Court of Appeals case for the District of Columbia in the Nextera, 9REN, and AES cases against Spain, they basically seem to push that off to a later date. They had obviously the US State Department's amicus brief urging them to prefer the arbitration exception, but almost from my reading of it, the approach that the US government was urging was to say the arbitration exception supersedes the waiver exception where you have an arbitration agreement, and should be the only exception applied. Is that something you think the courts will ultimately have to grapple with, or are they just going to keep?
Well, I can be very narrow and say, I if I win in my case on either ground, I don't look back and wonder whether the other ground might have worked. But certainly, any award creditor will continue to press the waiver exception. And there is a case called Tatneft against Ukraine that very convincingly holds the waiver exception applies. That was a case under the Ukraine-Russia bilateral investment treaty. Ironically, a Russian investor aggrieved by the way that the Ukraine government was treating it. Look, I think it'll keep going, this issue. And I will say that if you have an ICSID award, you have an even stronger ground for arguing waiver than if you have a New York Convention award. And the reason for that is the New York Convention simply says, look, we have a system for enforcing awards. That's that. The ICSID Convention says, and sovereigns have all ratified this, the sovereigns who are members of the ICSID Convention have all ratified it, says the award shall be final and binding, Article 53. It can be entered as a final judgment in the courts of every member state, Article 54. And then it says none of this waives sovereign immunity as to execution, Article 55. Well, so yes, we understand that it doesn't automatically open sesame to any asset of the sovereign being subject to execution in the member state court. But of necessity, that waiver only covers that phase. It does very strongly imply or recognize a waiver as to recognition and entry of judgment. And so I think that argument, which the High Court brought out very clearly in Anton, we tried to mine that decision for all it was worth in the DC Circuit. But as you say, they accepted the US Solicitor General position that if possible, they should avoid the issue.
And you mentioned the High Court decision in infrastructure services, and as you say, the High Court was able to be satisfied because of those features of the ICSID Convention that it met the customary international law threshold of a clear and unmistakable waiver that was necessarily implicit in once you construed the treaty correctly. And we've had two other cases, judgments that have come down since then, looking at whether that logic also extends to the New York Convention in the India cases. The investors being successful at first instance before Justice Jackman, but the full court then allowing India's appeal on a more narrow ground, which was looking at India's commercial reservation to the New York Convention. Obviously, you don't have reservations to the ICSID Convention, and saying that applies reciprocally, and therefore Australia doesn't have an obligation to India, and India doesn't require Australia to enforce awards which fall outside of the scope of that commercial reservation. And we won't necessarily say too much about that case. There's a special leave application which has been filed and is still pending, but that is another interesting point of difference, I suppose, between those two conventions, and an interesting development in the jurisprudence.
Yes, I agree. It's remarkable that the courts of Australia and the UK have had it, even for the UK, I think an outside's role, but certainly for Australia, a very influential role in developing the jurisprudence worldwide.
Happy to help where we can. The commercial transactions exception doesn't get a lot of airplay really yet. Certainly not here. It was an exception that was relied on at first instance, again in the India decision. That reliance wasn't successful. I think it perhaps both the exceptions in the US and Australia are crafted in terms that make it quite difficult to apply when you are dealing with an investor state award as opposed to an outright commercial award.
The problem is that in a treaty case, there's always the argument that it's sovereign activity that drives the treaty. But leaving that aside, I will tell you in sovereign cases, because I've done a few bondholder litigation cases, it comes back to you with a vengeance, the commercial transactions issue, when you're in the enforcement mode. Because in the United States, under Section 1610 of the FSIA, you can only attach assets that are used for a commercial activity. in the United States. And there's a huge amount of jurisprudence, mainly dealing with Argentina when it was in default, on whether an asset is or isn't used for commercial activity. We represented the Argentine pension fund, for instance, when it had monies on deposit in the United States. And one of the questions that could have been reached but wasn't is, does a state pension fund's investment of monies, is that being used for a commercial activity, that is investment, or is it being used for a non-commercial activity, that is helping pensioners running a social security fund? So that's when you'll get the issue come up, I think.
Yeah, and is the definition of commercial activity, or the way that the commercial exception to execution is framed, different in any material respect from the way it's framed in relation to immunity from jurisdiction?
It is. You can take jurisdiction over a sovereign in a dispute that either arises from commercial activity by the sovereign or relates to the activities of an SOE conducting commercial activities. The subject of the lawsuit has to be commercial activities. When you're attaching assets, it's a narrower thing, right? The asset itself needs to be used for commercial activities at the time of execution. Ironically, in my Argentine case, a week before the attachment, there had been a directive from the president of Argentina that all privatized social security funds had to be repatriated to Buenos Aires. And where we won on that case was repatriation of assets is not a commercial activity. So it is a narrower thing in the execution context.
Yes, I think that's similar here. We've got the commercial exception to execution is framed in purposive terms,
yeah,
which it isn't in relation to immunity from jurisdiction. It's just whether or not you've engaged in the commercial transaction or the like activity. But in the BIT context, at least, the courts have found that it's not the same thing to be a party to, say, a contract, and be the state that's just entered into a bilateral investment treaty that provides for arbitration. While we're on the subject of execution, one thing that I've come across, which I don't think we have a direct parallel for in Australia, is Section 1782 discovery, which I understand is used sometimes against states as part of an execution strategy. Can you tell us a little bit about what that is and how you've seen it used?
Against and by states. It's interesting. It works both ways. So Section 1782, actually a lot of Australian litigators love Section 1782. I learned about it in Australia before I came to the States. It's a general purpose statute that allows an American federal court to give discovery orders, that is depositions of document production, against anyone within their district in aid of a foreign tribunal, foreign or international tribunal. And that phrase has been interpreted as meaning any foreign court, and up to a point, any foreign investigative sort of quango or entity. It's got to be governmental. It can't be an arbitration. What that means is that if you're in live litigation in the United States, in a foreign jurisdiction, so if in live jurisdiction in England or in Australia, and one of the parties has a desire to get discovery, it can then issue a subpoena against a local American. There's a case where I think it was either Turkey or a respondent state that was seeking to set aside an award, Kazakhstan, seeking to set aside an award on various grounds in the courts of England, issued a 1782 subpoena against US parties that were allegedly involved in a fraudulent scheme that if proven, would have shown that the investment was a sham and shouldn't have been protected. It's that kind of thing that sovereigns have been using it for. The question is whether it's any use to award creditors. Maybe it's less used by award creditors because the more conventional path is to get a judgment in the United States and then issue an enforcement subpoena. That is, once you have a judgment in the United States, the courts are very generous about allowing you to take discovery of the debtor's assets. So I think look, it's a tool that you always need to be conscious of. My own experience is it's more on the sovereign side that it's been deployed in the setting that we're discussing.
And I've seen, at least from the Australian perspective, the courts don't like it when it's been sought first to get depositions, which they sort of judges raise their eyebrows at and say, well, that's a bit alien to what we do. Why would we sanction that? And also when it's been sought without first asking for the endorsement or approval of the Australian court, if it is in aid of Australian proceedings. But there have been examples where the Federal Court of Australia has been, not in an enforcement context, just in an ordinary commercial disputes context, has been asked to and has approved or endorsed the applicants going off to the US to make these sort of discovery applications in aid of their proceedings when it's for just production of documents that might not be available within the jurisdiction. That's interesting. Mindful of time, and we want to leave a little bit of time at the end for questions. I think there was just one final topic I thought it might be interesting for us to touch on, and that is injunctions against sovereign states, both anti-suit injunctions and sometimes you get anti-suit injunctions. As I understand it, in both the US and Australia, it is at least theoretically possible to get an injunction against a foreign state, and that's different from the UK, for example. Certainly in Australia, I'm not aware of any precedent for that being done, but I think there is in the US, although it's perhaps not easy.
Well, you know, I have the distinction of having obtained an anti-suit injunction against a sovereign. That was the case of Nextera against Spain, and the dubious distinction of having seen that reversed on appeal by the DC Circuit last August, because the Solicitor General of the United States told the court that it should be very conservative about enjoining foreign sovereigns. The Solicitor General believed that comity should deter the courts from enjoining foreign sovereigns from doing anything. However, the decision of the DC Circuit, you know, although I took the hit on that, it made clear that that's just a general policy, that there may be situations where the conduct of a foreign state is such that you should issue an injunction notwithstanding comity concerns. Now, I do still I harbor a problem with the reasoning of the majority, because there was a very well-written dissent from the DC Circuit. But anyway, you know, $2 will buy you a cup of coffee on that one, but or maybe $4. But generally speaking, the standard for an anti-suit injunction in the United States, which is pursuant to a case called Laker Airlines against Sabina Airlines, a 1980s decision. Look, you spent a lot of time just talking about that test, but if you boil it down, it's not that different from a decision of the Privy Council in Liqui Jack, I think is the name, against Aerospatiale, I think is the case. And it, again, is not that different from the guiding authority in Australia, as I understand it. You know, first of all, with anti-suit injunctions, it's a know it when you see it type jurisprudence. You sort of know as the litigant whether it has legs, an anti-suit application. You know instinctively as it's being brought whether it's likely to get a favorable reception at first instance. And then the legal test whichever way you boil it down, is all about whether the foreign litigation is a threat to justice and the jurisdiction of the local courts. I've been involved in another kind of anti-suit injunction, not involving sovereigns, that is actually more relevant to all of our practices. And it is the anti-suit injunctions from enthusiastic judges of the courts of India. And I would put that in a different subset of anti-suit injunction. But I've both defended clients that won an anti-suit injunction from the courts of New Delhi or Bombay, and I've been on the side of clients that have suffered an anti-suit injunction from those courts. And I would just describe that as a completely different art form. You have to deal very closely with Indian counsel in handling that kind of thing. It's just if you're involved in any kind of cross-border dispute with for or against an Indian party, it's just part of the landscape. You just have to learn about it.
Part of what makes our job so interesting, I'd say.
Yeah.
I think we have about 5 or so minutes left for questions. If there's anything people want to ask, either me or Tim, or contribute to the discussion based on your experiences.
I see some other veterans of the Davis case are on the line.
Yes. Hi, Lucy.
Hi, good evening, Tim. Lovely to see you again. It's been a while since I saw you. How are you?
Very well. How are you?
Pretty good, thanks. And I'm delighted to have it. At this time's much better for me than 5 p.m. my time, so I'm delighted to hear from you. And it sounds like everything continues to go amazingly well for your practice in New York, unsurprisingly. I had a question which is really recycling comments that I'm not involved in any of the Australian court enforcement litigation that's been talked about, but I've spoken to some of the lawyers involved in that. And one of the things that they said, and I'd be interested in your views on this, is that there is a perception, which is fantastic, that Australian courts are good quality and move reasonably quickly. And that's one of the reasons why the proceedings are being brought here in addition to the US and the UK. Is that consistent with what you're hearing from your clients, or is that just, hyperbole that us Australians love to hear?
Look, I think it's well known that it's a rule of law jurisdiction with high quality judges. In fact, what your comment reminds me of is years ago at a conference, a major oil and gas operator posed that, he sort of as a rhetorical question. He said, "Why isn't there more commercial arbitration in Australia? Because the courts are too good," right?
I heard the same thing. Yeah, I've heard the same thing from clients in the US. Yeah.
Yeah. And that's a high class problem, right? I think one of the factors that has been very good is at the federal level, as I understand it, you tell me but they can assign cases on a particular subject matter to individual judges with more experience in that subject matter. That's generally not something, as you probably know, you can't do that as easily in the United States because of the rules about judge assignment. You can play the percentages, right? So if you have a case involving, dealing in securities, you're more likely to find an expert judge in Delaware or New York, but no guarantees. So that's one of the things that I think has helped develop Australian jurisprudence. Another factor which puts you, this is more of a global, is appeals don't take forever, right? And that's another big factor. The UCOS case, although it, as you know, like Holland is a very well respected jurisdiction, right? But the UCOS award was in 2014. I think the final Supreme Court of the Netherlands set-aside decision was last year, if not slightly earlier. So that's, and that's a first world court, right? And there are similar war stories about the courts in Paris, which is another huge jurisdiction, you know, but you can be in the court system between the Paris Court of Appeal and the French Court of Cassation. You can be playing ping pong between those courts for a number of years, right? So that's not to have an appellate system that is relatively quick. And I think the Australian system is as quick as the English system, you know, basically, and no guarantee that you get to the top tier, right? It's got to be on special leave in both cases. Those are big pluses, and you know, being a place where people are basically honest is also a huge plus. That's to put too fine a point on it.
Any other questions from the group? No? All right, well, thank you all for joining us. Enjoy the rest of your day or the rest of your night, as the case may be. And thank you very much to Tim for your time today. Much appreciate you joining us. Thank you.
Well, thank you. And thank you for hosting me. Thank you for the opportunity.
Thank you, Tamlin and Tim. It's very good.
Thank you.
Bye, everyone.
Thank you.
Thank
Bye.
you. Bye.